Item number 3, AB 195.
Good morning, and thank you very much, Mr. Chairman and members. Today I present to you AB 195, and I think I could get started while my witnesses are coming up. AB 195 protects individual privacy by cracking down on websites that assist in the solicitation of a hacker to illegally access a computer network or smartphone. As we know, cybercrimes have significant and long-lasting effects on crimes. Because the personal information, when stolen, can result in identity theft, fraud, and personal embarrassment, all of which could take years to recover from, if ever. Under current law, it is a crime to knowingly hack into another's computer network without permission, but it is not a crime to solicit someone to hack into someone's computer without permission. In recent years, we have seen the growth of so-called hacker-for-hire websites, where individuals solicit hackers to perform certain projects. Some of these websites provide a platform for individuals seeking illegal hacking device services from unethical hackers, such as installing spyware on devices and gaining access to emails, social media accounts, and client list of the victims. AB 195 will hold websites accountable for the content that they promote, and also provide law enforcement agencies with a tool to deter those who wish to commit these cybercrimes. With that, I have two witnesses here today. I'd like to ask them to introduce themselves.
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office. In Los Angeles, the District Attorney has been tasked with ensuring the security of the entire county's computer network. As such, our specialized deputies and investigators in our high-tech crimes division monitor the dark web, where you see these hacker-for-hire websites. We frequently have attacks on the LA County system. This bill will help defend that. In addition, our stalking and threat assessment unit, domestic violence, family violence unit, and our sexual assault units frequently come across cases in which an abuser or perpetrator has illegally accessed the victim's either smartphones or computer networks to track their movements, to get access to personal information. These are very serious crimes, and our office believes that being able to crack down on an individual when they simply post the intent to have somebody be hired to do these types of illegal activities will help protect victims and government institutions as well as private companies. Thank you.
Thank you.
Good morning, Mr. Chairman and members. Lieutenant Wayne Billowit on behalf of the Los Angeles County Sheriff's Department. First off, we apologize for not getting our letter in on time. We've been a little inundated with bills recently, so we apologize to the committee for that. But we are very much so in support for all the reasons stated by the District Attorney's Office. Thank you, sir.
Thank you, and thank you for being so brief. All right, other witnesses in support?
Sean Hoffman with the California District Attorneys Association in support.
Khalif Osagai with the California Public Defenders Association in support.
John Lovell, California College and University Police Chiefs Association, LA Police Protective League, Association of LA Deputy Sheriffs, and Riverside Sheriffs Association, all in support.
Thank you. All right, moved by Assembly Member Gonzalez, seconded by Vice Chair Melendez. Let's see, witnesses in opposition. All right, and there being no witnesses in opposition, do we have questions or comments from the committee? All right, you may close.
I respectfully ask for a vote.
I am very enthusiastic about this bill. We've all had friends who've been hacked. Maybe you have been too. You get these crazy emails from their account where, you know, they're in London and they ran out of cash. And, yeah. So, I mean, it's endemic. And it's unfortunately, there are lots of tools out there for doing this. There are people for hire. I think this is a very sensible bill. I commend you for bringing it forward. My recommendation is aye.
Thank you very much, Mr. Chair.
Secretary, you may call the roll.
Motion is due pass to the Privacy Committee. Quirk?
Aye.
Quirk, aye. Melendez? Aye. Melendez, aye. Gonzalez? Aye. Gonzalez, I. Lackey. Lackey, I. Lowe. Lowe, I. Santiago.
Very good. Bill's out. Congratulations.
Thank you very much, Amber.
Assemblymember Obernolte, thank you for being patient.
It's my pleasure. Good morning, Mr. Chair, members. Before I was elected to the State Assembly, I served as the mayor of the city of Big Bear Lake. And I vividly remember the day after I was elected to my first term as mayor, my first official act was sitting in the mayor's office, taking a phone call from Marcia Slough, who is the presiding judge for the San Bernardino County Superior Court. And she was calling to officially notify us that our courthouse in Big Bear Lake was being closed. And a few months after that, they did indeed close our courthouses, and all of my constituents in the city of Big Bear Lake were then forced to drive an hour and a half down mountain roads to get to the nearest courthouse. And we were not the only ones. 5 years ago in my district, we had 4 courthouses. Today we have 1 courthouse. Our courthouse in Needles was closed. Our courthouse in Big Bear Lake was closed. Our courthouse in Barstow was closed and later just reopened to a single day a week. So this is a major concern for me because I have constituents in the city of Needles, for example, that if you want to take your landlord to small claims court right now, you have to drive to the nearest courthouse, which is in Victorville. It's 180 road miles away. So 360 miles round trip takes you 6 hours just in travel to go to court. So this is obviously a large issue in terms of access to justice, particularly impactful on people of low income, because those are the people who either A, cannot afford to drive 360 miles, or B, can't afford the time off because they're busy trying to support their families. So just to give you a little background about why I'm so passionate about access to justice and courthouse issues. So when I was elected to the Assembly, one of the first things I did was to contact the Judicial Council and say, what can we do as a legislature to help you be more efficient? What can we do to help you stretch the dollars that you have, given the fact that you don't have enough, to make it so that somehow these courthouse closures are no longer necessary? So this bill, AB 249, is a small answer to that question. One of the things that they brought to my attention was the fact that under current California state law, when a case is decided and that case includes the impositions of fines or fees, if there is an error made in the calculations of those fines or fees, no matter how minor the error, the entire case can be appealed on the basis of that error. And it goes off to the appellate court. The appellate court has to hear it de novo from the start, a whole different group of people, which is obviously extremely inefficient. So what this bill would do was make it so that if an error is found subsequent to a decision in fines or fees, that error is brought to the attention of the trial court, not the appellate court, and that's fixed at the trial court level as an administrative action and is not grounds for an appeal. And I want to be very clear about something. We're not trying to deny due process to anybody here. The language in the bill states very clearly that it's only if the error in the fine or the fee is the sole issue for the appeal that it has to be heard at the trial court and not the appellate court. So I'm going to respectfully ask for your aye vote on this, and I'd like to introduce Sharon Riley from the Judicial Council that will take you through the details.
Good morning, Chair Quirk and committee members. Sharon Riley on behalf of the Judicial Council. This bill, just very brief background, came out of our Criminal Law Advisory Committee and up through the Judicial Council. With me today I have our Vice Chair of the committee, Judge Cousins, to speak to questions and just a very few specifics about the bill. But as the Assembly member said, really the intent is to look for efficiencies wherever we can, and however small, but they do add up. Also, I would like to thank the Assembly member and his staff, who's been wonderful to work with, as well as the committee staff, who really came up with some excellent clarifying amendments. So with that, I am going to turn it over to Judge Cousins.
Mr. Chair and members, thank you for giving me the opportunity to speak on this bill. This is really a small efficiency measure that affects the appellate courts mostly. As indicated by the Assembly member and Sharon, there's a great deal of staff time devoted on the appellate level to correct these minor things. We think it's best to bring it up to the trial judge first, and I can tell you as a trial judge, I would much rather clean up my mess than have an appellate court tell me that I did it wrong. So I think from every standpoint, this is a very simple and effective change that we seek your approval for. Thank you very much, and I'd be happy to respond to questions.
Thank you. Other witnesses in support? Any witnesses in opposition? Thank you.
Lee Foster Guy with the California Public Defenders Association. We were opposed to this measure based on a jurisdictional issue that's since been resolved with Judicial Council and Assemblyman Obernolte. We appreciate your willingness to work with us, and we're no longer opposed.
Oh, okay. You could have just come up in support.
Could have.
All right. Move the bill by Assemblymember Gonzalez, second by Vice Chair Melendez. Questions, comments from the committee? I'll make the comment that I really appreciate your working with your Judicial Council and with the public defenders for bringing this bill forward. You may close.
Thank you, Mr. Chairman. Members, this is a common sense measure. It improves the efficiency of our courts, and I'd respectfully ask for your aye vote.
I agree very much with the members' close and urge the committee to give their aye votes. You may call the roll.
The motion is due pass as amended to appropriations. Quirk?
Aye.
Quirk, aye. Melendez? Aye. Melendez, aye. Gonzalez? Aye. Gonzalez, aye. Lackey? Aye. Lackey, aye. Lowe? Aye. Lowe, aye. Santiago?
It is out, and I wish you the best of luck as this goes forward.
Thank you, Mr. Chairman.
Thank you.
Thank you.
Mm-hmm. All right. Now our Vice Chair Melendez will present her bill, which is item 4, AB 225.
Thank you, Mr. Chairman and members of the committee. I am here to present AB 225. Last year, AB 1014 established the process for petitioning and issuing a gun violence restraining order known as a GVRO against an individual who poses a significant danger to himself or others, or having his or her custody of a firearm or ammunition. GVROs are extremely serious orders that do significantly affect the life of a person they are being filed against. Despite the reasoning behind the petition, it is very important that the person filing the order is truthful and honest. Under AB 1014, the penalty for filing a false petition is a simple misdemeanor. It's a slap on the hand. Knowing the long-lasting effects of a GVRO and what it will hold against an individual, I think the punishment does not fit the crime. AB 225 is a deterrent against filing a false petition for the GVRO, and it would increase the existing penalty for perjury from a misdemeanor to a felony. I know that probably makes the chair cringe, but there's good reason for this. This would bring the penalty into consistency with other false filings for restraining orders, an example being a petition for a domestic violence restraining order, which would be a felony. It is our responsibility to ensure public safety. It is also our responsibility to ensure that the laws that we pass are not abused by people who have ill intentions. This bill is supported by the California State Sheriff's Association, the California Rifle and Pistol Association, the Gun Owners of California, and the National Rifle Association, my husband, my children, and all of my family members. And here today to speak on behalf of the bill is Ed Worley and Tom Peterson, and I respectfully ask for your aye vote.
Thank you.
Good morning, Mr. Chair and members of the committee. Tom Pedersen on behalf of the California Rifle and Pistol Association in strong support of AB 225. I want to thank the author for bringing this matter forward. This is a common-sense bill that will serve as a strong deterrent against an individual knowingly filing a false gun violence restraining order petition. The bill strikes a good balance between legitimate filings and discouraging false claims by petitioners. By increasing the penalty to a felony, you are putting individuals on notice that knowingly filing a false gun violence restraining order petition will result in serious consequences. On behalf of the membership of the California Rifle and Pistol Association, I urge your aye vote. Thank you.
Mr. Chair, members of the committee, Ed Worley with the National Rifle Association. I want to thank Assemblymember Melendez for bringing the bill forward. It's nice to come to the committee and have a nice common sense bill that's fairly straightforward and nicely tailored. Because as a citizen of the state of California, I think everybody should be very diligent in when they're filing court papers. That if you're going to file court papers to start putting somebody through this illegal problems they're going to encounter doing this, it should be taken seriously. And if you're going to attest that somebody has done something wrong, that they're going to have their rights restricted, that it should be a felony, should be consistent with everywhere you're going. It should be a felony to knowingly lie and to knowingly mislead the court. Because remember, these are court documents. So this is a consistent issue. We thank Assemblymember Melendez for bringing this forward. It's very straightforward and very common sense. Thank you very much.
Other opposition, other witnesses in support.
Mr. Chair and members, Corey Salzillo on behalf of the California State Sheriff's Association in support of the bill.
Thank you. All right, witnesses in opposition. You have up to two witnesses, 2 minutes each. You may proceed. And which two of you will be the witnesses in opposition? Have you decided?
I'll be brief, so. Okay.
Okay.
Khalif Ostagai with the California Public Defenders Association. We're opposed to this measure. This conduct can already be charged as a misdemeanor. We don't think that there'll be a deterrent effect by increasing it to a felony. Furthermore, these petitions are already filed under penalty of perjury. So while we understand what the Assemblywoman is trying to accomplish with this, we don't think that it adds anything to this area of law. So we're opposed.
Very good.
My name is Amanda Wilcox. I'm here on behalf of the 25 California chapters of the Brady Campaign to Prevent Gun Violence. Many of our chapter members, including myself, have lost a loved one to gunfire. We were very strong supporters of AB 1014, the Gun Violence Restraining Order bill last year, because the bill supports our core mission, which is to keep firearms out of the hands of people who show dangerousness, who are dangerous people. We realize that there are individuals who are a serious threat because of heightened despondence, anger, substance abuse, or they're in an emotional or mental health crisis, but they may not have a firearm prohibition, and there does need to be a way to disarm these dangerous people. I appreciate the author's concern about potential abuse. We actually shared that concern last year. We do not want this legal tool to be abused, and to that end, the bill was significantly amended. It was narrowed, and the standards are very high standards, and also the bill is amended to add a misdemeanor if there was a false report or intent to harass. We think that will take care of the issue, and right now we feel this bill is a solution to a problem that does not exist. This bill has, the Gun Violence Restraining Order law has not gone into effect yet. In Connecticut, which has a similar law, I have not heard of any cases of abuse or false reports. The author mentioned the seriousness of a gun violence restraining order and how much that will impact someone's life. That's true. The worst case scenario, I guess someone would lose the right to have a gun for a year. The alternative, of course, is losing life, and that is forever. So I think that increasing this penalty to felony is really disproportionate to what the crime would be of a false report and what the potential benefit of the bill is. Having the threat of a felony would have a chilling effect on families that are in crisis, searching what to do, taking the big step, a significant step of going to the courts. We need to help families do that, not discourage it. Thank you.
Thank you very much. Other witnesses in opposition?
Thank you. Jim Lindberg on behalf of the Friends Committee on Legislation of California. I'll just echo the concerns conveyed by the prior two witnesses, and just to add that we think that the legislature ought to proceed very cautiously and sparingly when enacting new felonies. Numerous jails are under consent decrees to limit population, and being as this law it just became law in January and hasn't even been implemented yet, we don't think there's a basis for tinkering with the law without knowing that it's not working. Thank you.
All right. Questions and comments from the committee. Assemblymember Gonzalez.
I just have a question because I've now heard two different things, or at least in my background material from the staff. Is it a felony punishment for California's domestic violence protective order to?
If you file it with the court directly, it is a felony. It's actually...
Wait, so I'm being told by staff that
Can staff come and talk to me here?
If I could just add, Mr. Chair, if you don't mind, while you're conferring, this is the form that you fill out for requesting a domestic violence restraining order. On the very last page where you sign, it says, I declare under penalty of perjury under the laws of the state of California that the information above is correct and true.
It says, it says under penalty of perjury.
Correct.
Which is also what it is for the gun violence.
If you file it directly with the court, that is a felony. If you file it with the police station, that's different. That can be considered a misdemeanor. Depends on where you file it.
All right, let me check.
And I should add, while they're conferring, that the bill that I have also, if you file it with the police station, that's a misdemeanor. If you file it with the courts directly, that's a felony. So the distinction is the same.
So your belief is it would line it up with the same rules applied for the domestic violence filing.
Exactly.
Thank you. What I'm hearing is, yes, it can be perjury, but only under fairly special circumstances. You have to show that they were knowingly, they did this knowingly, they did it with malice, et cetera, et cetera. You could go to court and you could get a felony perjury, but that's not going to always be the case. It depends upon the circumstances. But I think you made your point there.
It's the same as for the domestic violence restraining order.
All right.
The same rules apply.
All right. Other comments?
Yes, real quickly. I think it's something we've got to be very, very careful when we're decriminalizing the intentional desire to being dishonest. That's what's at dispute here. Are we going to decriminalize? And there's a difference between filing a false police report and perjury. And so I think that that's a very delicate distinction. It's a misdemeanor to file a false police report. But when you're going beyond that, and the courts are recognizing this as court testimony, that's a whole different standard. And so we have to be very, very careful that we're sending a message of intolerance for willful, intentional dishonesty. That is the point. And so I hope that we will send the message that that's intolerable, and we need to send the most powerful message we can that it's intolerable.
All right. Go ahead, Assemblymember Gonzalez.
I'm going to be really clear. I came prepared to vote against this or to stay off of it because, quite frankly, I thought, well, let's see if there's a real problem that needs to be fixed. I am not amused that in my background material from the staff of this committee, under argument in opposition, it states, additionally, there's no similar felony punishment in California's domestic violence protective order statute upon which GVRO was in part modeled. I understand that came out of somebody's opposition letter, but it was a clear indication, and I think a clear indication to my staff and to myself, that there was a differentiation being made. I think that our laws should reflect one another. I think the willful violation in filing against somebody, regardless if it's a gun law or domestic violence, having been through, quite frankly, a divorce that was not pretty. I know how these things can happen. I'm prepared today to make a motion to support this bill.
Is that your motion? Yes. Okay. Second. All right. If there are any other comments?
Mr. Chair, you don't have any questions for me? I am so disappointed.
I'll make my
Okay.
recommendation after you close.
Okay, thank you, Mr. Chair. And Assemblymember Gonzalez, I appreciate your comments and your change of heart. I know this is a difficult issue, and I recognize the desire of this committee, generally speaking, to not increase penalties and to not put laws into place that would put more people in an incarcerated state. However, I have some points I'd like to make. First, the member from the Brady campaign, I very much appreciate her comments and agree with many of them. And I also support keeping guns out of the hands of people who are going to harm others with them. We're totally in line with that. But my disagreement comes in that the rules aren't the same for filing for a gun violence restraining order and filing a domestic violence restraining order. And I think we've already shown that. And I think when you look at, we're talking about the potential for someone to do harm to another. Whether that is with your fists or that is with a handgun is irrelevant. Okay? It's irrelevant. We're talking about the same issue. This bill isn't about gun rights or gun control. This is about filing a false petition for whatever the reason is. Assemblywoman Gonzalez mentioned that, a divorce, and that sometimes that can be very ugly, and that's true. So think about for a moment, let's say you have a teacher who's going through a messy divorce, and there's a custody issue concerned with the kids. One wants custody, wants to get it from the other. Very simple to file that gun violence restraining order maliciously. And then what happens to that teacher? Is that teacher removed from their position because now parents are complaining, saying, well, I heard that there was a gun violence restraining order. I don't want this person around my kids. Not to mention the effort, the time, the money, the retaining of a lawyer to.
We only allow 5 minutes for members with opening and closing. Could you?
How many do I have left?
Sum up.
What do I have left? 2 minutes.
What do you have left? 30 seconds.
30 seconds. Okay. Well, I will just again implore you to recognize that this is not a gun right or control issue. This is about the penalty for filing a false complaint, and I would ask that you recognize that it is the same as filing a domestic violence restraining order. There should be no distinction. I don't recall hearing any members of the opposition speaking against having it be a felony if you file a false DV, so I don't understand why they're opposed to it being a felony for a GVRO. Thank you, Mr. Chairman. I respectfully ask for your aye vote.
All right. Thank you. So I feel differently as you, and here's the reason why. What we're trying to do with this restraining order on having a gun is to prevent someone who is mentally incapable of handling that gun properly. To tell someone, perhaps a brother or a father, if you can't really prove this is a felony on you, I'm worried that would be a deterrence. Now, it's a misdemeanor as well, and a misdemeanor that can be punished, and I think that is adequate deterrence against making a false claim. And I will now ask the committee to vote no on this issue with me, and we'll see what happens. Madam Secretary, you may call the roll.
The motion is due pass to appropriations. Quirk?
No.
Quirk, no. Melendez?
Aye.
Melendez, aye. Gonzalez? Gonzalez, aye. Lackey? Aye. Lackey, aye. Lowe? No. Lowe, no. Santiago? No. Santiago, no.
So the measure fails on a 3-3 vote. You're welcome to ask for reconsideration when we have a full committee.
I will certainly do that. Thank you, Mr. Chair.
Very good. Thank you, Madam Vice Chair. What was that?
Unanimous consent.
Okay. So we need unanimous consent. Does anyone object to reconsideration? Very good. We'll break this up again.